In early 2020, COVID-19 spread from China throughout the world, becoming a global pandemic. Nations, states and cities had to quickly take measures to try to overcome the spread of the pandemic. It had been 100 years since the previous pandemic, so no one had dealt with one in the modern era. Western Australia responded to the pandemic by establishing a hard border. Already one of the most isolated states on the planet, they instantly decided that nobody gets in and nobody gets out. From a pandemic perspective, it was spectacularly successful. But even during a pandemic, governments must be subject to the law. In this case, governments must be subject to the Constitution. Section 92 of the Constitution says that trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Clive Palmer, a businessman and former parliamentarian, travelled frequently to Western Australia to conduct business. When the pandemic hit, he asked for an exemption allowing him to cross the hard border, and this was refused. He challenged that refusal on the basis that it restricted intercourse between the states, which was supposed to be absolutely free. Now, the court had previously decided that absolutely free didn't mean absolutely free. In previous cases looking at trade and commerce, the court had found that the idea of those provisions was to prevent a protectionist policy, whereby one state imposes duties on the goods coming in from another state. And so policies which did not have protectionism as their goal, policies with some other legitimate purpose, could be implemented even if they restricted trade and commerce between the states. Nobody had ever really tested that in relation to intercourse because notions of protectionism aren't really relevant to someone simply travelling to another state. The court applied the same reasoning though. Justice Gordon said the Western Australian laws, in their application to an emergency constituted by an epidemic, comply with the constitutional limitation of Section 92 of the Constitution. They do not impose an unjustified differential burden on interstate trade, commerce or intercourse in favour of intrastate trade, commerce or intercourse. They are not discriminatory. From this case, we learn that it is valid for laws to restrict intercourse between the states, provided they do so for a valid, reasonable purpose, and provided the restriction is proportionate to the objective. Palmer lost the case.